Hello and welcome to the 14th episode of the ArbCast podcast. Today we are joined with Mr. Pallav Mongia to discuss the draft arbitration bill 2024. We acknowledge that this is not even a bill, let alone an act, but that is precisely why this discussion is happening, since the purpose of this draft is to invite recommendations. We will also be discussing the general arbitration landscape in India that Mr. Mongia has experienced in his 17 years of practice and understanding why Arbitration Act is so prone to amendments. Now, if an introduction to Mr. Mongia's credentials is to be given, it will take an entire episode itself. So, keeping brevity in mind, he is an advocate on record before the Supreme Court of India, and he is also a solicitor in England and Wales. He is the associate member of 3 Hale Court London and is an alumnus of the National Law School Raipur.
Hey, hi Ardit. Thank you so much for having me. Obviously, it was long due, and thank you for having me here. And we are lucky to be here together, and let's have an interesting discussion on something which is very relevant and it's going to be relevant for a long time.
Yes, thank you. The pleasure is entirely ours. Thank you for your time. Now, to begin with the conversation, as I mentioned at the outset, that this particular topic of draft arbitration bill, before we get into the nitty-gritties of it, why is it that the Arbitration Act is so prone to amendments, right? From 2015, it has been amended 3 times already, and there's another draft bill that is being discussed in Parliament. Apart from the Income Tax Act, perhaps this is the most prone act to be amended. So why is this happening? Is it that the practice of arbitration is actually provoking such amendments to take place? And do you think this is the right approach to make India a more attractive seat, not just for international arbitration, but also for domestic parties for domestic arbitrations?
Right. I think that's a great question, and I will just look at it the other way. I mean, why not? I mean, shouldn't the government be congratulated for being responsive, for taking inputs from the practitioners and try and amend and bring the statute in line with international practices, or trying to cure the mischiefs which have crept into the system? I mean, on one hand, we complain that our CPC or our Evidence Act doesn't get amended. And now here is a statute which is getting amended. So I would say arbitration as a statute, see, it regulates commercial dispute resolution mechanism. So, and resolving commercial disputes, regulating them, ensuring that they get resolved, has a deep connection with the economy, how the economy runs, how the investments are attracted in this country. So, uh, I believe that the government is concerned that we create a genuine environment where disputes can be resolved. And if we give this certainty to the investors, then more investments come in, commercialization happens, and that indirectly affects the economy. So, yes, I mean, being alive to the situation and being alive to what is happening in reality is a great step. I think the amendments were long due. So the government has woken up. They have taken cognizance of the fact that arbitration statute and practices and the entire ecosystem must be in line with the international standards. And then they are taking measures to ensure that they are observing the judgments passed by the courts. They understand where the lacunas are, and now they're trying to cure it. So I would say that's a great step that the government is being alive to it, the lawmakers are being alive to it, and they are ensuring that they plug the loopholes as fast as they can.
Yes. So while you welcome such amendments, what is your general overview, like a very general nutshell of how you perceive this amendment, draft amendment bill of 2024? What do you think is should be welcomed and should not be welcomed, and your basic analysis of this entire amendment?
See, the bill itself is quite comprehensive, so I don't think I can comment or recall every aspect of it. But a couple of things that really cross my mind are really beneficial in nature and also show that some homework is being done. Is, for example, the endeavor to resolve the issue of place versus seat. So now the lawmakers are quite clear and they want to put in the concept of seat and get it recognized legislatively so that the confusion comes to an end, the challenges to arbitrations come to an end on this ground. So that's one very welcome step. And then, of course, the introduction of concept of emergency arbitrations, giving its due recognition. putting it out there explicitly that emergency arbitration is permitted. The institutions are encouraged to do emergency arbitrations. I think that's also great step. And then making amendments to Section 9 and Section 70 to ensure that they get complied with their enforcement mechanisms. The fact that if there's a jurisdictional challenge or that should be resolved as a preliminary issue, that's also a welcome step because there was, as a in practice, if you see, a lot of tribunals had this practice that the moment somebody would raise a preliminary issue, they would simply set the same, we would decide at the stage of final hearing. So that would defeat the very purpose and creates an anomalous situation as well, where I don't know whether tribunal at the end of the trial, end of the arbitration, would be inclined to say that, look, we did not have jurisdiction in the first place. So to avoid these kind of situations, the law now says please resolve this as a preliminary issue. And this also is fair to the party which is challenging the jurisdiction. So that's also a welcome step. So overall, I believe that yes, it's alive to the situation. The Arbitration Council of India has been further amended. That was introduced way back in 2019, but that issue seems alive. Like seems that the government is still cognizant of it and wants to take steps to ensure that it becomes a reality. So all of these are, I think, generally, if I were to say that most of it is welcome, most of it is a genuine endeavor to resolve issues, be responsive to what the court are saying, and plug the loopholes.
Yes. Yes, so that was a very good introduction to the general overview of the amendment. I would just like to highlight a couple of nitty-gritties which I think are, which perhaps needs a discussion and some criticism also. So you sit as an
Right.
arbitrator also, and you're a counsel also. You have seen it from different capacities, this particular process of dispute resolution. And the narrative that slowly is developing in India is that judges are appointing retired judges as arbitrators, and then once they retire themselves, their successors will appoint them as arbitrators. So it's just the same group of people, as Toby Randolph puts this, the members of the mafia, appointing each other. What happens in this is that while they are obviously very competent jurists, they are may or may not necessarily be they may not be an expert in commercial disputes and have industry specific knowledge, which practitioners like you or even non-lawyers may have. Back in the day, arbitrations were adjudicated by and even non-lawyers also who were industry experts on principle by principle, not necessarily by law and case law. So
Right.
if arbitration is that in the most purest form is that, why is it that only people from the legal fraternity and specifically certain group within that are being appointed as arbitrators? Bearing this in mind, this draft amendment bill, is also imposing another restriction, which is that instead of now you being a graded arbitrator, which is a 2019 amendment concept, you also now have to be like a recognized arbitrator. So long as you don't recognize, you cannot be appointed. Now, this again puts a barrier to those who are, let's just say, not coming from a legal fraternity and who don't have resources, but are very well known and have understanding of the subject matter. So, what do you think of this replacement from being graded as one to be recognized one as a precondition, as a condition precedent for you being appointed? Do you think this is a welcome change? And what are your analysis about this?
Right. I think that's a great question. And there are a lot of questions in that question. So I'll try to remember each one of them and try and answer. If I missed out, just let me know and I'll answer that aspect as well. Starting off with this thing of retired judges as arbitrators, I don't see anything being wrong with that generally. I mean, the fundamental requirement of being an arbitrator is having a judicial approach to a dispute. Ordinarily, we are dealing with commercial dispute, which may have a lot of nitty-gritties, which may have a lot of correspondences. A construction dispute may have a lot of aspects. A basic requirement to ensure that that issue gets resolved in a fair manner is to have a judicious approach. So one reason why retired judges are preferred as arbitrators is because judicious approach in is ingrained in them. It's in their blood after having sat as judges for so many years. So I see absolutely nothing wrong with retired judges being appointed as arbitrators. What has happened is that when we narrow it down to say that mostly only retired judges should be appointed, when we narrow down our selection to a list of retired judges, that's where the problem starts. So, yes, there are amazing senior counsels out there who are doing a fantastic job as senior counsels in commercial disputes. They have technical knowledge. Somebody would have sat in 4 or 5 construction disputes as a counsel, would get very good knowledge of basic issues of construction law, or somebody who has some experience in dealing with oil and gas would have very good industry knowledge of oil and gas. So they will also make excellent arbitrators. And having been counsels in court, they also are ingrained with judicious approach. So I believe that even the counsels of great reputation should be considered for sitting as arbitrators, and that would be a great step because it also calls for the bar. It just makes the bar more participative in the arbitration ecosystem. It is not just about senior counsels acting as counsels and then doing the arbitrations, but also setting them on the bench on the side. That uh, would also make them more involved in the ecosystem and would also add credentials to the entire system because now we are not there cannot be any shortage of number of reputable arbitrators. Number two, yes, now it is a well-known fact that of course the young counsels who have time in their hand and who have already spent 10, 15 years at the bar, they may also be good additions to the the arbitration bench, and to that extent should be options, should be viable options. And in fact, one thing I observed is that I'm coming back to my first point, which I made, that the problem comes when the selection list is restricted to retired judges. And then within the ecosystem, you get certain number of judges who become very famous and they are doing an excellent job. And then they are very, very sought after, and then they become very busy, so it's very difficult to get time from them when the arbitration stretches. I think this is where the problem lies. So once you increase the purview, you increase the choices that one can make of good arbitrators. I think that will really change the game. And we often ask ourselves, what can India do to make itself a great seat for arbitration? I think the first starting point would be having an excellent pool of arbitrators who are genuine. There's no corruption. They are knowledgeable. They are professional. There are no adjournments. There's commitment. They read the brief and come. They have exposure to urgent side. So, all of these, if you have a good pool of these arbitrators, I think you are sorted because the better arbitration you do, the better process is followed, the less are the chances of it being set aside in the challenges, etc., etc. Less are the side consequences of fallout, the unwelcome fallout of a bad arbitration. So that way, I think increasing the pool is a must, and inviting other people, other factions of other practitioners to the bench, to the pool of arbitrators is a great welcome step, something that should be done. An aspect of your question also dealt with the non people from non-law background who are technical people. I think that's something that's been as practice going on for years now. Even if you look at, for example, commodity arbitrations or arbitrations in stock exchanges, etc. So they always have a pool of people who are technically sound in those trades, who know how those trades happen, how does international trade happen, how do agri commodities get priced, etc. So they are also an excellent addition to the pool. And being in the trade, of course, they would be aware of the practices, malpractices, and what kind of documentation can be required to cure a certain defect of a certain point. So that way, they are an excellent addition to the pool. One thing I would always suggest is that yes, technical people are always welcome, but technical knowledge alone is not enough to make you a good arbitrator. What makes you a good arbitrator is the judicious approach, an approach to fair process, natural justice, and a basic knowledge of original site litigation on how things are proved I think and that does not mean that I'm calling upon to for Enforcement of Evidence Act or Application of Evidence Act to proceedings, but just that basic knowledge, that basic norms. I
Mm.
think once they are taught and once they are ingrained in you, I think you can make an excellent arbitrator. And that also gives me a segue to answer the last part of your question about young practitioners or this shift from grading to recognition. I think, see, like I said, that this basic process, that basic knowledge is required. That and it's less of a knowledge, it's more of an attitude, it's more of a practice, it's more of a open-mindedness that howsoever obvious the case might be, you still give other side a chance to prove their case. Don't take that away, howsoever understood things are, because that's how the process is, that's how the trial goes. So while yes, arbitration is not supposed to stick to technicalities of evidence or CPC, but at the same time, fair opportunity has to be given to both sides.
Yeah.
So the concept of recognition, I think, comes in that please undergo some kind of a training. You are outside the legal system. You don't have these things ingrained in you. You are not aware. Something you didn't know, you don't know. So you'll have to go through that process. So please train yourself, learn about the basic process. And once you get that recognition, you are absolutely great. So there's nothing lacking in you. Nobody's saying that you are lesser qualified. Is that some skill set is required, which if you obtain will be a great asset and will make you a great arbitrator. So I think that minimum netting off or filtering is definitely required. But once that basic qualifications are there, that basic attitudinal change is there, then definitely there's no stopping. Then there is no distinction between somebody being a retired judge and somebody being a technical expert. I think both would make excellent arbitrators.
Yes. That's a very insightful and very nuanced answer to this question. But staying on the topic of developing narratives and you sitting as an arbitrator, so there's this new concept that is developing in the world of international arbitration specifically of due process paranoia. For those who are not aware, I just elucidate what exactly does it mean. So in arbitration, the onus of the arbitration concluding within a set period of time is firstly on the arbitrator because he is the master of the roster. So you have to ensure that the arbitration is being completed within a set period as determined by statute or otherwise. So that is one responsibility of an arbitrator. The other responsibility of the arbitrator is to make sure that both sides are being heard, not just on main arguments, but also the nitty-gritties and everything that the parties may feel that needs to be brought to the tribunal. So at times these two obligations may conflict with each other, and that leads to due process paranoia, where arbitrators don't know what they should do, whether they should hear a claim or an argument or proceed with the arbitration and conclude it within a set period of time. So, as you sit as an arbitrator, how do you approach this challenge of ensuring that both these obligations are being accommodated by you in an arbitration?
See, I think that's a challenge that we all face. In courts, also judges face this challenge. And you always want to draw a line between fair process slash abuse of process. You want to give everybody a more than welcome chance to put out their case. And at the same time, you don't want to be in a situation where somebody's avoiding service for a couple of months and then suddenly shows up and says, now please hear me. So that balance has to be drawn. And speaking for myself, I think walked right into this question because in my previous answer, I was talking about the fair process and the judicious approach to disputes. So I think speaking for myself and generally also, I think one should always err on the side of caution. And in this case, caution would mean fair process, judicious process. Because look at the whole hierarchy of the arbitration process. In an ordinary civil dispute which goes to a court, you have a trial and then you have a first appeal, and then you have a second appeal, and then you have Supreme Court. And in law school, when we are taught about first appeal, the basic thing we are taught is that human beings are prone to errors, judges are prone to errors, and therefore there should always be a first appeal. And therefore, the scope of first appeal is very wide. It's a reappreciation of law and facts. But aren't arbitrators prone to errors? Can't arbitrators make mistakes? Now look at the hierarchy, at least on paper, what the arbitration ecosystem provides, the Arbitration Act provides. There's an arbitration, which does not happen in open court. It happens behind closed doors. It is not done by a judge, but by a private party sitting behind closed doors. He's not a public servant. He's just a private person appointed. He's not staying in a government accommodation, etc., etc. He's a private person completely outside the government control. He's sitting in a private room and deciding a dispute. I personally believe, and look also, which is seconded by the reality we face in the Indian ecosystem, that the standard of fairness in an arbitration, yes, or standard of transparency in an arbitration should be higher than that you may require in the civil court. Because there is no first appeal against an arbitration. Once that award is passed, it's supposed to be the final word on facts and to some extent on law. Because even errors of law are not prone to challenge under Section 34. So practically you have missed the bus. This is your only chance to prove your case. And then you see the number of challenges that succeed in courts. Ordinary statistics would show, and it's an accepted fact, that in India, the number of challenges are higher. The number of challenges that succeed are higher than than most other developed nations or in most other developed seats. So the point I'm trying to make here is that let's err on the side of caution. Let's give everybody a fair chance. Let's go that extra mile to ensure that everything is looked at properly, proper application of mind takes place, and then the dispute is decided, and then the award is passed. Because once that is done, at least on paper, and mostly so, that the door is closed, you cannot re-agitate your case. In CPC, we have provisions like Order 41, Rule 27, where we put in additional documents. In Section 34, you don't even have that, except maybe on the grounds of fraud, etc. You may be able to skip in some additional document. But where is your opportunity to strike again? If you have a bad counsel in arbitration, you suffer. If the arbitrator doesn't look at your documents, you suffer. The arbitrator doesn't apply his mind to something very important, you suffer. So all of these are very serious consequences. And therefore, yes, I mean, there are instances, there are parties who want to abuse the process. They would avoid service for the longest time, and then they would suddenly show up and please allow us, etc. Uh, yes, those parties are there which would take a lot of adjournments, and they would say things that you can't really object to. If somebody were to just come and say, "Look, there's a family emergency or medical emergency," you can't say no. Okay, the entire day is booked, right, for a trial, and somebody would just come and say, "Look, there's a family emergency, adjourn the matter." So yes, the process suffers. I mean that, but yes, you have to be. I believe that as much chances as many that can be given should be given in this. There are other things that can be done to deal with this paranoia or the abuser process, and that could be done through cost or closing somebody's opportunity, like, or passing stern orders, or giving short deadlines anyways to ensure that even if there are adjournments, it still matches the timelines, so on and so forth. So other things can be taken, but I believe, and especially in the Indian context, one should always focus more on the fair process.
Yes. And I think one more point that I think you would agree on also is that there's no hard and fast rule to approach this problem. I think it's to be adjudicated on case to case basis how the parties and the councils are behaving. If you can identify a council is purposefully trying to delay the arbitration, then you do it, then you address it that in that particular manner as it needs to be addressed. And if you think it's genuine, then you have to obviously hear the parties. But that ability to differentiate between if it's a genuine or a not a genuine request is what experience does, which that is why you need experienced arbitrators. That is, which is also adding on to the previous answer that you had given that you need to have training to be an arbitrator, and you can't just be an arbitrator right off the bat. So I'll move on to my second last question, which is that in almost every other conference and every podcast, including this one, we always ask our guests as to how can we make India, because this is primarily an Indian origin arbitration broadcast. How do we make India a global hub for arbitration as a seat where not just Indian parties are choosing as India as a seat, which they have to because that's where the offices are and for their own convenience, but also parties who are not Indian, neighboring countries or even countries which are developing or developed countries. So why would they choose India as a seat, and how can we compel them to choose India as a seat? So how can we make how can we make India an attractive seat for arbitration? And
I
just
think
one more point to this question.
yeah.
And in many of these answers, people usually talk about how supervisory courts actually go a step beyond what they're supposed to do. So in line with what I've just asked, or if you can also talk about Section 34 and how challenges of awards are being approached, because that is also a very essential aspect of ensuring that the arbitration is efficient. So just on these lines, if you can answer and tell us your insights about this.
I think if it's okay, I just try to answer the second question first regarding the challenges under Section 30. See, my experience is that my understanding on the entire issue is yes, we always criticize the courts that they intervene too much and there are too many Section 34s being allowed. But one picture that a lot of people miss is also the admissible standards of awards that are passed. I mean, sometimes it really shocks the conscience if you look at the award. If, the government is cognizant of the fact that there's corruption in arbitration. Yes, if the courts get an indication of there being some underhanded deals or some corruption or some favors being done, then yes, the courts will strike it down. And even, I mean, look, the application of mind, the due process, the lack of experience of original side, and all of these are factors which lead to awards where the courts have no option but to interfere. The timelines, the how arbitration stretches years after years, the amount of time which is spent between the reserving of the judgment and then passing of the award, that itself is shocking. And there was a recent instance where I think it was more than a year time lapse between the reserving of the closing of proceedings and then the passing of the award. So all of these factors are there which leave the courts no option but to interfere. If something is shocking and something that goes to the root of the matter, then the courts will interfere. I think what really troubles us and what also allows me the opportunity to answer your first question now is the just the time it takes to decide a particular petition. The fact that Section 34 is being filed, a challenge to an award is not a problem. The fact that it remains pending for many years, that's when the circumstances change. And I'll give you a recent instance also on how just this timeline and this pendency affects our entire approach. Is you look at the recent judgment of on the amendment of the award, the power of courts under Section 34 to amend the award, Gayatri Balasan. In that judgment, a lot of these aspects were widely criticized. I also personally wrote something about it, and I said, look, these aspects are not right. And of course, some aspects of the judgment also, I think, if you are really laying down that the courts can interfere and modify the awards, then you should lay down some strict and clear test so that it's not left ambiguous, and then the high courts have some or the lower courts have some indication on how to go about it, so that it's not abused, this new provision, this new source of law. So all of that is there, but the power to amend the award in when it is challenged before you is not a new concept. It's there in other jurisdictions. So what is the problem? Where does the problem lie? The problem lies in pendency. The fact that it remains pending for so long, that's where the problem lies. For example, if you were to amend the award or send it back to the arbitrator, but if you do that 5 years later, then who all are there? 5 years later, you say, okay, this question was not determined or this factual aspect was not determined. I'm setting it aside or adjourning it. Please go back, reconstitute the tribunal, call the expert witness again, and redecide this factual issue. who will remain there for 5 years? Maybe the arbitrator is no longer there. He's retired. He stopped taking. He's busy in some other arbitrations. He has expired. The expert is no longer there. He has moved to some other company. Maybe expert was hired from some expert organizations, and he has moved on to some other organizations. The councils have changed. So many things happen. So it's not exactly, the problem does not lie in the grounds of challenge. That's more or less borrowed from the ancestral model law. The issue lies in pendency, and then pendency is a systemic issue. I mean, if the bail matters remain pending, if the under trials are languishing in jail, and if it takes so many years to decide appeals, once they're admitted, 10 years, in some high courts more than that, then arbitration is also just another branch of law which is tagging along with those. So there's nothing new. So what we might need to do is not criticize the judiciary for it, but maybe tweak the law in a manner that there's less opportunity for this pendency. That could be one way to go about it. And number two, just to deal with the systemic issues. And number three, of course, promote other forms of dispute resolution, that for perhaps maybe mediation, etc., which just removes a lot of pendency. Maybe does not lead to disputes, don't lead to arbitration. That could be one way to go about it. I think another stark difference I see in practice between India and other jurisdictions is cost. I think India as a jurisdiction, we are not that, don't impose those many costs. And yes, imposition of costs also requires a fundamental change of approach from our end also. I mean, end of the day, we are more equity-based jurisdiction, right? We want, the judges here want to do justice. They want to help the poor. They want to have help the person, a smaller company, a David versus a Goliath situation. So equity always has a room in our Indian system, and that's really, really appreciated. And that's something that's an essential part of our system, because that's how our country is, that's how diverse our country is. But when this equity system creeps into hardcore commercial disputes, then it becomes a bit of a problem. Then the certainty, legal certainty, a certainty of outcomes has to become paramount consideration. See, for example, in other jurisdictions, before you file a suit, commercial suit, or you file an arbitration, you are very sure about your case, how you want to proceed, because you know that if you lose, there are consequences you suffer in form of cost. But that's not the fundamental criteria that we look at before we initiate. If we think we are wrong, we straight away go file a suit or we initiate arbitration. And sometimes we feel that we know that the other side is being wrong. So now we take the preeminent step and file a suit ourselves or arbitration ourselves, just to delay their claims, etc. So I think somewhere that distinction or change in attitude has to take place, where we rule out equity from commercial disputes and say that, look, if the contract says this, if the email says this, then that's the end of the matter. We decide by the black letter of law, and this is what the provision says, and this is what it is. So cost also is something can be looked at, but not in isolation, but also carrying forward with it the other changes that are required to ensure that cost regime is also a fair regime. And so that's also one aspect I think we can all look into. And I believe that if we really understand this regime, understand this cost issues perfectly, and we apply them, this will definitely reduce the pendency, will definitely make parties and lawyers rethink their position before filing cases. So that could go a long way. Then, of course, I think one place where I believe that the Indian system is lacking and could do a lot is somewhere the Indian system ends up rewarding the wrongdoer. The delay in outcomes allows the wrongdoer to benefit from his or her own breach. For example, if somebody has pocketed the money and is not giving the money to the other side, then it takes a lot of time for the courts to say that eventually, yes, this money was owed to the other party, please pay up with this much interest. If you look at it as a pure investment scheme, I mean, if the markets are giving return of 12%, he would say, look, I'm not going to give 1 crore I owe to the other party. I'm going to put this 1 crore in the market. I'm going to make 12% out of it. And when the courts eventually give a decision against me, they will simply say 6 to 8% on that money, and then I will return the money at 6 to 8%. And I will also lose after 5 to 10 years only when I actually lose. There could be 100 reasons why I might win, or the other side may fail to establish their case. And that applies in other things also. For example, we see so many, specific performance cases, agreement to sell happen, property disputes, and then they are not executed eventually. All of that, and then the property cost rises, and then there are judgments to say that specific performance should not be awarded if there's a stark difference in the prices, etc. And then, of course, now there's a recent amendment which says that no, compulsorily you have to. But this has been the trend which has trickled down in the conscience of the nation, the commercial community as such. And you can get away with a lot of things. And I see that happening when Indian parties are also dealing with foreign parties, since they think it's a tall order for a foreign party to come to India and then sue us and then wait all this time to ensure that their money is recovered. It's a tall order, and so I might as well pocket the money. I was representing an American company once some metal had come to India and the Indian party had not paid. And when eventually the negotiations happened, and after I'd filed some case, and then when they were cornered, they eventually settled the matter with us. And once the settlement was all done, I asked him that generally, I asked them, why did he not pay? So they said, no, we were going through a bit of a bad phase and we thought it's an American company, when they will come, when they will sue us. So that just gives us time to recover. So, this kind of mentality is there. So we are kind of, rewarding the wrongdoer. We are giving them breathing space. So that should not happen. So one way to cure that could be reforming our damages jurisprudence, where we are focused very much on the actual losses suffered by the party which has suffered because of the breach of the other side. And does not act as a penal mechanism. It does not say that I'm going to punish you because you actually breached. So that jurisprudence is a bit lacking in India. And even liquidated damages, the courts hesitate and still insist sometime on actual damages suffered. So all those things of course, bring in the equity angle into it, and to the extent the courts can't be blamed, they are being fair. But the point is that end of the day, there are two big commercial parties. Suppose some power plant is being established. There are two big commercial parties. They understand their risk. And will all lawyers, advice, and everything, they enter into an agreement which has a liquidated damages clause. Then to go back to the other regime and still insist on actual proof may not be required all while. So, these are fundamental things. And of course, dependency is a systemic issue. You can say 100 things about it. And I think that will really take the discussion beyond the scope of this podcast. But yeah, I mean, whatever can be done to cure the systemic issues, that can be done to reduce dependency, the time it takes to resolve an issue. uh, I think these are the ones, but mostly on paper, India is not doing something extra. On paper, everything is fine. It's just that if we resolve these practical issues, then we'll be able to make a lot of difference and allow a lot of parties to arbitrate in India. And I'm just reiterating my first point, which I started the discussion also, having an excellent pool of arbitrators. I think that's where we are really lacking. And in India, there's one thing you cannot say, that we have dearth of talent. We don't have in any field in the entire world. India does not have dearth of talent. We are just too many out there. And there's no dearth of good people out here. We just need to bring them in the system, reach out to them, give them incentives to be part of it. And I think it will change a lot in the arbitration ecosystem in India.
Yes. So thank you so much for that answer. And I think what differentiates this answer from other answers is the fact that you answered in the context of India and not and in the context of India and other areas of law, not just arbitration. So in a country where there are more under trials than prisoners, obviously it's by default, by extension, that commercial disputes will also be extended and delayed because matters pertaining to liberty are being also delayed, which is
Correct.
utmost importance. So that is definitely one insight that we got out of this answer. Now, I would like to conclude this episode with one last question, which is that which we ask almost all of our guests, that the majority of our audience are young law students, young aspirants, young lawyers who aspire to be arbitration and dispute professionals. So, since that you've practiced for almost around 2 decades, in this practice area, what is that one key advice that you would give to them so that they can also have a career like yours?
See, the advice would be that, see, a lot of people come to me and they say they want to be arbitration practitioners and they end up doing a lot of courses on international arbitration and everything. But what they miss out on is that end of the day, you're deciding a dispute on the original side, right? There's going to be a trial, not in strict purview of the Evidence Act or CPC, but there is going to be some factual adjudication and not in a summary manner, a lot more than a summary manner. So first and foremost, have some working knowledge of the Evidence Act and CPC. People who commit themselves to arbitration, they completely ignore these statutes. You should know how to prove a document. You should know how to prove a fact because only these principles apply in arbitration. So have that basic knowledge. How should one cross-examine? How do you do final hearings in a case where you already have some cross-examination that has taken place? All these things are very, very important. A particular fact which the client is coming and telling you, how will it eventually play out in the trial, in arbitration, or in court? When I say this, would the other side say this? Will I be able to prove this? How will I prove this? Who do I need to call as a witness? Which document can I show? So eventually, it all boils down to having that basic working knowledge of Evidence Act and CPC and how to conduct a trial. So don't miss out on that. You have the time now. You are starting out your career, so you have the time. So read those statutes as much as you can. Think about it. Think about how this argument or this document will play out during a trial, what the other side has to say. So all those things are very important considerations. So this will give you a very solid foundation as a dispute resolution lawyer, as an original side lawyer. And then you can, of course, chart out your course as in whether you want to be an arbitration counsel or you want to be a litigation lawyer, you want to be in court. And if you have this grounding, then you will be a good counsel everywhere. But vice versa may not be true. So don't miss out on this aspect of learning, especially in your early years. And yes, a lot of arbitration is keeping yourself abreast with knowledge of law, the latest developments. And all these readings will give you a bird's eye view of things and will develop your basic knowledge and IQ and thinking process in with passage of time. So keep doing that. Like we discussed initially, that one reason uh, the Arbitration Act is so prone to amendments is because so many things happen in that ecosystem. It's very dynamic. And since this involves so much of exchange across borders, there's so many good things to learn from outside. And that is why such change happened. You see those issues playing out in court, somebody using a judgment from Singapore or UK or US, and then individuals couldn't tries to adapt it or some modification of it. So that is why it's so dynamic. So keeping yourself abreast of all these developments and leading and changes will really, with passage of time, develop you as a good arbitration counsel. And lastly, of course, and that applies generally. I hope you land yourself in good chambers with good bosses who give you that opportunity to learn, to think for yourself, and grow as a lawyer. And once that happens, then there is no stopping you. I think India needs great arbitration bar, and there have been so many initiatives to do it. And I hope you start well and be a part of this arbitration bar. And there is no stopping. So all the best to everyone who's out there listening as a young arbitration practitioner.
Thank you so much, Pallav, for this constructive and very warm advice to our young audience. And it was an absolute pleasure to host you. It was a long time coming, as you had mentioned at the outset. So it's great that it has come into fruition finally. And I hope you had a good time having a conversation with us and joining us on this podcast for this particular episode. So thank you so much for being here, and we hope to host you in the near future also.
No, absolutely, Hadid. Thank you so much for your time. Thank you for bringing me here. It was an absolute pleasure. Thank you for those questions. I think it really allowed me the opportunity to share my thoughts and give a bird's eye view of how I perceive things and but to share my 2 cents on the issue. So thank you so much for this opportunity. And of course, since arbitration is so dynamic, I'm sure there'll be so many changes that we'll have an opportunity to do our discussions again.
Certainly.
So it's a pleasure being here. Thank you so much.